Hello friends, in this particular episode, we'll see how to cross-examine in criminal cases. And for this, we have with us Advocate Tapan Thatte, who is into practice since last 13 years and conducting criminal trials. From him, we'll understand what are the techniques, tools as to how the cross-examination should be done. So first of all, Mr. Tapan Thatte, thank you very much for giving your time. I would like to first ask you, what is cross-examination?
This question is perhaps, I would first want to make a reference to what is cross-examination. So we directly turn to the legal definition of it, which will read as 137, examination of a witness by the adverse party shall be called cross-examination. So whenever any witness turns up and he is called by an adverse party, so your examination of that witness is cross-examination. But that I would rather term it as a very pedantic way of looking at things. The reason being, then we are missing out on a larger thing as to what you expect from cross-examination. So I would want to define it from the functionality point of view. And in that case, it will have 5 implications. Firstly, cross-examination is a method where you elicit material from a witness which either renders his testimony irrelevant in terms of section 5255 or insufficient to prove a given document whether by reason of section 65, 67, 68 or rather you take an admission which excludes his testimony by reason of section 91, exclusion of oral evidence by documentary evidence, or render the witness incompetent to depose in terms of 118 to 130. And lastly, which is also a part and a very small part, though too much heavy reliance is placed on it, is that rendering him unworthy of credit. So from the functionality point of view, examination by an adverse party to secure all these ends or any of these ends would be termed as a cross-examination.
Okay. Then I would like to ask you, how advocate should prepare himself for a cross-examinations?
So that is a question, it is a very interesting question. If we just look at that, preparing for cross-examination. So I would say there are 2 broad categories under which you need to prepare. So there is one, the legal side of preparation, the other is psychological side of preparation. So in the psychological side, we may say in that corporate lingo, it is key player analysis. Now let us come to that legal side first, which is easy to understand, particularly to the new entrants to the bar. So firstly, the legal side, you must know the substantive law or the offense with which you are charged with. So knowing the ingredients right is one thing. Then making a list of all the admissible or relevant material against you in terms of section 5 to 55 is other part of it. And then weighing as to what really hurts your case as an accused is something which is of consequence. I will just give you an illustration. Suppose it is a murder trial based on testimony of an eyewitness. So it is the testimony of eyewitness which hurts you really. Whether there were fingerprints on the assault weapon or not is rather in the backdrop. Yes, that is important, no doubt about it, but that is not what is hurting you. So I would say knowing substantive provisions and preparing a list of what actually hurts you is the legal side of it. Now the other side of it is psychological side of it. As in knowing psychology of the key players is something important. Now key players may change from every fact situation, but there are 3 key players which will exist in each and every trial. First being the judge, second being the witness, and third being your own client or the person who is accused of an offense. Knowing their psychology is also matter of preparation. So if I have to sum it up, preparing for cross-examination or what ultimately you must be able to prepare for is that making a list of admissions which you are seeking from every witness, one thing, having regards to of course the legal side and the psychological side. And secondly, a rough plan as to how you are going to use those admissions at the time of final arguments. Unless you have these two things ready, each and every witness, whatever you have done is under preparation. So that is what is preparation in brief. If we can.
Okay, so just now you said that that final arguments need to be kept in mind while doing cross examination.
Yes.
That is a necessity.
That is the necessity, because that is what you are going to use it. Cross examination is not some empty ritual ultimately. It is that how you are going to use it at the final argument stage will dictate as to what you must seek. So the preparation goes other way around as to how are you going to argue, you go for your final arguments, and to support your final argument what you want. So you must have a rough plan of final arguments as well as a list each witness.
Okay.
Without one, the other is impossible.
Okay.
It goes both ways. Yes.
I would like to now ask you one thing, that how to frame outline of your questions. Like, are there any segments in which you can divide it?
Outline of your question, I would rather get into the preparation part a bit first than that. See, ultimately, let us have a reference to section 2 definition under Evidence Act. Just part wise I would want to answer. Firstly, Evidence Act does not decide as to how much reliance court must place on the relevant material. Right. So it will only make a list as to what is relevant. Now what the court must rely on and how much, that is not dictated by Evidence Act. So ultimately it is for the judge to decide as to when there are countering materials available, as to where he leans more. And let us go back to the definition. What is the difference between proved, not proved and disproved? It is when the judge feels that a fact has occasioned, that is proved. When he feels that the fact is not established, it is not proved, or rather has not happened, it is disproved, and anything in between is neither proved nor disproved. All right. Now the problem is that you must know the psychology of the judge as to what appeals to his individual. Secondly, we are still on preparation, but without this preparation is impossible. Now, what appeals to him as a human being, that human element we can't escape. So that is one side of preparation. Secondly, what is your client looking for? Is he looking for an acquittal with honor? So there can be three broad categories what he is looking for. Acquittal with honor, that is a very burdensome accused. The reason being, he makes you not only defend the case, but also makes you attack the prosecution case. Then what is he looking for? He may be looking merely for acquittal, no matter which ground. And lastly, he may be looking for mere release from the prison. That's all. So even if he gets sentence equal to what he has undergone, he is still happy, because that is what he is looking for. All right. So even that you have to keep in mind. And thirdly, when you come to the witness, you must essentially understand that witness, the very fact that he is being called by the adverse party, has some sort of a grudge against your client. There is some sort of fight between you and that witness. And under the circumstances, that witness to start with is going to be on the defensive. So keeping all these points in mind, I would say, and also having regards to the law on the point, I would say preparing for cross-examination, we just discussed that even it must have reference to the final arguments and also the... So preparing for cross-examination, I would say that there are 4 stages of it. Okay. So first you go for caging of a witness, as in get all possible material, which, or I will say it other way around, you prepare a final admission list, this is what I want from the witness. Then first get all admissions from him which may compel him to give you that admission, and then you suggest your case. So without these ideas being ready with you, you have not prepared for the cross-examination. If that is what answers your question, or you put me a specific question, I can answer you better. But that is what is preparation for cross-examination, not exact. Perhaps I have not been able to put it through and through, but that is what you prepare for cross-examination. Yes. any other thing.
That is caging. And
Caging.
then other further are there
Yes,
further
yes.
stages
See,
for that.
How it goes. Let us say Mr. A is trying to prove handwriting of Mr. B, who has committed illustration is necessary. Mr. A is trying to prove handwriting of Mr. B in order to prove his suicide note. What he deposes in his chief is that I am acquainted with handwriting of Mr. B and that is how I prove this suicide note. Now, when you say that a person is acquainted with handwriting, reference ought to be made to the explanation of section 47. There are 3 instances when a person can be said to be acquainted with it. I am trying to prove that there are 4 stages: caging, conquering, enslaving, and then suggesting. So that first caging. Now the final thing you want from the witness is that Mr. A is not acquainted with handwriting of Mr. B. But if you start with the first question that you are not acquainted with it, he is bound to say no. End of it. So there is nothing more you can get out of the cross. So first, you logically eliminate all possible ways by which he can substantiate his stand. So having regards to 47 and rather caging him, rather cornering him where there is no logical option left at his disposal, you start with that suppose A is an office colleague. So you say that all exchanges between you and Mr. B were through either SMS, WhatsApp, email. Email was always replied by an email. And then in a later when you say in today's era, nobody writes letters. Either you call or you put a WhatsApp. And with that, the last thing you also say when Mr. B wrote his suicide note, you were not present. Logically, he has to say, yes, I was not present there. And then you say that you are not acquainted with his handwriting. Or there was no reason, no occasion for you to be acquainted with his handwriting. The first part what you have done is you have logically eliminated all explanations which he can give to say that I was acquainted. And now you have caged him. Now, but to accept your suggestion, he is not left with any other alternative. And that is how you take him out of that explanation, and now that suicide note is not proved. That is how you trick him. So that first part is caging. Conquering is rather a result of caging, where he is not left with an alternative but to yield to your suggestion. The third part I would say that, but it may not work with each and every witness, but it particularly works with police officers or rather over smart witnesses. That may be a very offensive term, but that is how a cross examiner looks at it. So the third thing is enslaving. When a police officer, I will go by police officers because that is what is generally relevant in criminal trials, is caged and conquered, and rather you start suggesting, or rather this is an aggressive part of it, that he has erred in his duty, or that there can be some sort of a rather backlash on him in under departmental inquiry. Then just to save him, he will not bother about his own case. He will not only give you admissions, but he will start destroying other witnesses as well. And that is where the element of enslaving comes in. Because you have caged him so much, rather conquered him so much, that he is not left with any other alternative but to just surrender to all your suggestions and avoid all the inquiry. Enslaving. And the most important part, this is not cross-examination but rather a rule of prudence. No matter whether a witness is privy to a particular fact or not, to each and every prosecution witness, put your full defense story. Because unless you put your full defense story that this is my version what has happened, let him keep denying, but that is necessary because without putting those sort of suggestions, you cannot argue it at the last point. And that is why 4 stages: caging, conquering, enslaving, and suggesting your defense. This is how the outline it goes. And the questions must be grouped in that way. Yes.
Now, as you are saying, you are going to ask questions. One interesting fact arises when particularly you are asking a question and it is not being allowed by the judge to be taken on record. So, what should be the reaction, or how a lawyer should tackle such situation?
Yes, that is a thing which every cross-examiner faces at some point or the other. Now the thing is, let us go to the objections of questions. Now if we turn to the objections to a question, there are two parts of it. Now generally what I see at trials is that judges, they start objecting to a question because it is irrelevant. Alright. And then there can be another category, especially under POXO prosecution, Protection of Children from Sexual Offences Act. Another category that either the cross-examination is too aggressive, or the questions which you are asking in precise words indecent or scandalous. Let us come to the first part, that the question is irrelevant. Now the thing is, here the dictate of law is dictated by 149 and 150 of Evidence Act. It is the duty of the advocate not to ask irrelevant questions or questions which have no ground for you to ask. And if at all an advocate asks such question, then it is for the court to report it to the Bar Council. In the first flip, the court can't say this is irrelevant and therefore I don't allow. So that you must know what is the precise law contained in 149, 150, that only because it is irrelevant the court can't stop you. Relevance will be decided subsequently. Correct. You are free to ask questions. But if it is a question which is scandalous or indecent, and this is especially or rather aggressive in POXO prosecutions, then the court can really stop, they can stop you. So you can mellow down your questions, keeping your focus on what admission you want rather than getting into character assassination of a person. However, there is one more category which somehow falls in between. Now let us go to that section 53A, which was introduced by way of Evidence Act, which was introduced by way of 2013 amendment, as to previous sexual experience of prosecutrix in a rape case is irrelevant. But the fact is that it does play a very major role. So the judge is going to rather stop you from asking, and that is where you need to understand the psychology of the judge. So because it may not be strictly relevant as such, it may not be strictly indecent or scandalous, but it falls in that grey zone. Alright. So here is where your relations with the judge or your demeanor matters. But otherwise, only based on relevance, question can't be stopped. However, a question, no matter how relevant it is, if it is indecent or scandalous, it can be stopped. That is how it goes. Yes.
Now coming to cross-examination of expert witnesses. So how to conduct that, because the people who come as expert witness obviously are doing their particular act or activity day to day.
Yes.
So how to cross-examine expert witness?
That's a very interesting question to ask. As the general opinion goes, let us first look at the general notion of Evidence Act. Witness is supposed to be a witness of fact and not of opinion. What I have witnessed is of consequence. What I think about a situation is inconsequential. However, in case of expert witnesses, this position stands reversed. He is not a witness. Suppose a doctor comes in a murder prosecution, he has not witnessed anything. It is only his opinion which is important. And therefore, what is relevant is opinion of a person specially skilled in that foreign law, art or science. That is the word, specially skilled. One thing. So that is the dictate of mandate of evidence laws as far as section 45 is concerned. Now from a practical vantage point, expert may be knowing more and more about a field, but that is not where a cross-examiner stops. Cross-examiner, from his point of view, it is, expert is a person who knows more and more about less and less. So that मुन्ना भाई dialogue goes that दिमाग के डॉक्टर को मालूम नहीं है घुटने में क्या हो रहा है. Okay, that is how it is. So whenever you want to cross-examine a expert, never take him head on, because he is actually an expert. So he knows much more about that field than what you can even think of. Don't take him head on, point one. The second point is that expert, or rather I'll put it this way, expert is his own enemy, because knowledge will give you humility. So suppose I am cross-examining an orthopedic and I start asking him that in case of spine injury, ultimately you will need a consultation from neurologist as well, is something which takes that injury at least partially away from the area of his special skill. And that is where he becomes irrelevant altogether. The moment he says that though this is my opinion, I would need confirmation from a neurologist, whatever he has said in his chief comes under cloud. So the cardinal principle is don't take him head on, and that more and more about less and less. So try to shrink his area of expertise by his own admission.
Okay.
Trying to take him head on is the worst mistake you can ever commit.
Okay.
Okay. Yes.
Now, as we see, the entire way of functioning of society is changing. Social media is playing a very major role. Obviously, now cases of criminal nature will happen because of social media, maybe on a Facebook or a YouTube or Insta, whatever you see. Now, how to conduct this case, which is solely arising out of social media, and what kind of a preparation or study has to be made when there is a social media case?
And with your permission, I would just want to expand the horizons of this
Please,
question,
please.
because social media has become such an integral part of your life or our collective lives that we cannot merely say that offenses based on social media and other offenses. It cannot be that way, because even if we go for a 138 prosecution, there always will be some element of electronic information technology act. Ultimately, even social media is nothing but a particular use of existing information technology. And therefore, I would want to expand it to say that it is not only a particular or a genre of offenses where the social media is relevant, but even otherwise in a criminal trial, knowing the use of information technology, which has become an integral part of our life, is essential. I would want to give you an illustration now how important it is, and knowing their policies. Now, since December 2019, this is a charge sheet which I am right now reading. Since 2019 December, if you want to log in into your Gmail account, you will need verification at least from some other device which allows you to log in. So there is a two-factor authentication. So either it is through your mobile or some other trusted device, and merely knowing your password is insufficient. Now the case of this girl under 304B goes this way, that in her suicide note, she said that I was being harassed and that is why I committed suicide. By my in-laws, I was being harassed and I committed suicide. That is what her suicide note reads. That's quite brief. But almost 1.5 months before her death, her brother claims that she had written an elaborate email as to how she was being harassed by each of her in-laws. And she further says that all my mobile phones were taken away, and because nobody is at home right now, I have logged into my Gmail account from the laptop of my husband, and this is how I am sending you email. Now this email is of December 2020. Now we just connect the policy of Gmail and this email. The fact remains that after December 2019, she could not have sent any of such email. The reason being, her own case, mobiles were not available, no other device was available. So where is the two-factor authentication? How could you log in? That is why knowing their policies, their functionalities is something which is quintessential, not only in offenses or rather arising out of social media, but even otherwise.
Okay.
That is how it goes. So even for a Snapchat user, the case that a girl and a boy were in some relationship, and girl used to keep sending nudes on Snapchat, and the boy kept taking screenshots. Of course, on a Snapchat, if you take a screenshot, the other side will get a notification. All right, and this is how it goes. Knowing, or rather, this is how Snapchat works, goes great length when you prepare for your cross-examination.
Okay.
So you must know social media and this IT and how their functionalities.
Okay.
Yes, sir.
Identically, I want to ask you one question, that whether the method or a preparation of cross examination varies from different acts, like for example offences from IPC, the offences from say Anti-Corruption Act or say 138, whether there is a difference or you have to have the same set of preparation for everything.
Sir, the point is, yes, it will differ on some technical aspect. The difference would be what the substantive law underlying the cross examination changes, but that is a part of question itself. But I would want to suggest everyone that losing generality of this preparation as to knowing the judge, knowing witnesses, on all these things, they remain to be the same. And the moment you lose generality and start adverting that I am a 138 cross specialist, it doesn't go that way. The reason being, the techniques which you are using, they are uniform to each and every prosecution. I would want to go a step ahead. Even in civil cases, the method in which you are preparing for your cross examination remains the same. So a note of caution, whenever you are preparing for cross examination, don't get bogged down by saying that I am only 302 specialist, 138 specialist. It is nothing like that. Either you know how to conduct cross examination, prepare for it that way, or you cannot prepare for it. No offense specific cross examination doesn't exist.
Okay.
Yeah.
One more thing just going in my mind, that we refer to the case laws in our final argument at times. So obviously, as you had already said, that final argument has to be kept in mind. Identically, the cross will also depend upon the case laws which you want to refer at the final, at your arguments, that the contents which you want to extract and then connect it to your saying that, sir, this is a case law and this is what has happened.
Yes, of course, because see, ultimately case law is deciding the substantive law or whatever the section of law which you are depending your case on, fulcruming your case on, is ultimately decided by case law. But rather case law explains the meaning of that section. So let us take it. So I would want to just sum up what I have been saying so much. Let us go to the Yaqub Memons case law of 2013. Okay, it talks of many things, but one of the important part, I suppose it is paragraph 357 if my memory is right. It talks of when is Panchnama admissible. So let us first know our substance right. Now we are talking of case law and how we use it. I have just expanded it to say that let us combine everything we have discussed and formulate a question. Now a punch witness deposes at the court, and in order to corroborate him, a Panchnama is brought on record. It is given a proper exhibit. Now the fact is, Panchnama is not a substantive piece of evidence. It can only be used for corroboration and nothing more. Now what you are aiming at is you want to strike out this corroboration part of it. Alright. Now there is another section 162 which says that the statements recorded by police are cannot be proved in any court. At least, okay. So what you want to do is you want to convert this Panchnama into that bar of 162. Now Yaqub Memons case law says that the IO must record Panchnama as if it were a narration of the punch, and if the punch concurs with what he has recorded, then he will sign at the foot of it. But if it so happens that the punch has narrated the Panchnama, that is nothing more than a statement under 161 which is inadmissible. Alright. So now I know this case law. Alright. Further, I know the psychology of the witness, that he wants to say that whatever he is deposing, that is how it happened. So now I put him a question by saying that police has recorded the Panchnama the way you narrated it to them. Now this question is masked in the first place. It is masked. It is not giving out the object. In fact, it is counter suggestive of the object in the sense that the punch feels that I am trying to help him. It is also tempting in nature, really easy to understand. So he latches at this opportunity, says, yes, this is how it happened. And the Panchnama was recorded the way I narrated it to the police. And ultimately, using this case law at the final argument stage, I just take out this Panchnama because now it is no more admissible.
Correct.
So knowing substantive law is important, but knowing substantive law and case law together when it aids in framing of question, that is what is expected in preparation level.
Okay.
If I have answered your question,
Yes,
this is how it goes. Yes.
Now, at the same time, we have lot of books in market. So many questions of cross-examination and all that. To what extent they can be really helpful? Some extent they are, but to what extent I would like to say.
The thing is, ultimately, Grantha hates Guru. So, to say that they are completely irrelevant, don't look at it, would be an extreme. And to say that rely on those books and you are done with it, that would be suicidal. I would point it this way. So, getting a brief idea as to how you must frame questions, or rather generally in a given situation what sort of questions are asked, is good for when you are trying to prepare a list of admissions or list of questions in your cross-examination. But depending on them, as in that you may get a heading that how to cross-examine Punch, remember there is no straitjacket formula. There is no straitjacket formula. That is why cross-examination is an art. And therefore, that human element, human touch, what happens is when you get that rather tied down by the book, your own brain stops working. So they are helpful, but I won't say more than 10%. Yes, for a student it is good, but that can't be the basis on which you prepare your list qua witness, which we have been discussing.
Okay.
But you must read those books. There is no escape to it.
Okay.
Yes.
Now, one question which arises is, what should be the handling technique of a witness? Some advocates are very aggressive, some are. So, what kind of a technique you feel should be adopted while doing cross? Because we are dealing with a human being. We are not dealing with anything which is. So, how it can be done?
Yes. So, the thing is, we again go back to that key player. So, I started with the judge is a key player because ultimately he decides what happened, what did not happen, one thing. Then I said that the witness is a key player and even your client is a key player. We will come to that client later. A problem is that when a witness is called by the adverse party, remember that he is certainly adverse to your client. An eyewitness of a murder is not going to be a friend of your accused because the police will not select him as a witness in the first place. So the thing is, preparation or rather witness oriented preparation, handling of the witness, that is what you asked me. It starts not when the witness steps into the witness box, it starts even prior to it. So the first and foremost, or rather I observe many criminal lawyers committing this blunder, is that loitering in corridors of the court even before your matter is called out and allowing the witness to identify you with the cause of your client is something which is a blunder, because then there is a case of that transferred malais, the tortious principle, that whatever malais he had against your client, now he starts attacking you with it. Or rather he gets defensive the moment you ask him first question. A defensive witness is not going to give you admissions. One thing. The second thing is that when you are dealing with a witness, you are supposed to trick him into giving admission. So this is some sort of a anesthesia which you administer and not a sword. So if you try to cut the witness into half, he has full protection. There is no way you can physically assault him. The thing is that you must be able to misdirect his attention and then get some sort of admission. Like we were just talking of this Punch who came here. He wants to advert the cause of the police. But in his over exuberance, he has ended up destroying his case. Alright. So if I had identified myself with my client, then my face as an independent person goes away. Alright. So we as lawyers, we know that no matter what happens, I always want to save the client. But that is not how a witness looks at a lawyer. For him, everything is alien. He is stepping into a new arena altogether. So you are maintaining a neutral face, being friendly to him, misdirecting his attention. That is what the basis of handling a witness is. Okay, so you start cross-examining, we were talking of experts. In a foul language or an insulting language, he will get defensive. That is not what you want. You want the witness to be in his free mind and inadvertently support your case. So that is the basis of it. Of course, it will depend on witness to witness what you are trying to go.
Okay.
Yes.
Now, one more question which arises from our key players, like our own client is a key player. Now, based on our suggestions or requirements of our client, cross-examination, how that cross-examination has to be done as to what our client wants.
Okay. So we were just discussing key player analysis. So just for easy reference, there are three players: judge, witness. We have discussed about it. Now, when it comes to our own client, ultimately you are a tool in his hand. Okay. No matter who the client is, you are just a brain on hire. So trying to go ahead with the cross without knowing what he wants from the cross is again a blunder. So for that, from that vantage point, I would want to categorize our clients, basically a person who is accused of an offense, under three categories. The first is a accused who is fighting for his honor. Alright. Especially we see this in defamation cases. Now in defamation cases, no matter whether he suffers conviction or not, he is always going to get benefit of probation of offenders. It's a very trivial offense. And in any case, there will be appeal, there will be revision, and at some stage, he will always escape imprisonment. That being so, in the defamation offenses, you will see that people, they don't fight, or the accused is not fighting merely because he wants to escape imprisonment. He is fighting for his honor. This is one type of accused. Now, I will come to how the questions they change. Then the second category is quite easy, and that is the accused who is fighting merely to escape conviction, no matter on what ground. And the third category is where he merely wants a release from prison. Even if he suffers conviction, he is least bothered. He just wants to be out of the prison. The first category, somebody who is fighting for honor, is burdensome for a cross-examiner, because not only you have to create a doubt as to the prosecution case, but then you have to go ahead and kill the case of the prosecution as to disprove a particular case. So he is putting a burden. As far as the other two categories are concerned, they are quite commonplace. Now, how question changes? Well, let us come to an interesting case. Let us say A, B, C, D, E. A real case, but I don't want to disclose names. Five of them are accused of assaulting Mr. Z with sickles, choppers, whatever. Now, the injuries which they have caused are innumerable, but interestingly, the injuries which are caused on the torso and the head are not such which individually are sufficient to cause death. Alright. And now, since the 307 offense is punishable with imprisonment for life, they have already spent, having regards to the seriousness of the offense, they have already spent 7 years in prison. Now, I know they are regular gangsters. Okay, or perhaps while discussing with the client, I can decipher his intention that I just want to come out of the jail, no matter how. Now, I ask a question to Mr. Z. Now, we are combining all these ideas. I ask in his testimony, he is not going to say that I don't know ABCD. That is not going to happen. So, I merely put him a question that while assaulting you, they also said that the next time should you dare to do a particular thing, we will cut you into pieces and murder you. Okay, this is not what has happened. But now this Z wants some sort of a sympathy. All right, he thinks that you are a neutral person. The question is so tempting that he wants, this is also what he said. All right, and that is why he said, yes, this is what he said. At first, this question would appear absolutely stupid, but now it has the effect of taking the offense away from 307 and make it an offense under 308, for which the maximum punishment itself is 7 years. They have already spent it. They give a damn about whether they are convicted or not. But the fact remains they are out of the prison now. So at the final argument stage, you just come up with an argument that I may be guilty of 308, but right now you have to send me out of the jail. So that is how it changes. Based on what your client wants. And that is where that confidence building between you and the client is important. So you want to rather take a client who is fighting for honor and tell him the reality that this is not a battle of honor, and therefore don't burden me with something extra because that is dangerous. And at the same time choose between the other two categories whether I should go for clean acquittal or should I just get conviction for a lesser offense, which is even sufficing my purpose. So that is how the things will change. Yes.
Okay. Now, since we are talking about cross-examination, are there any type of crosses like like say suggestions more or searching more, something of that sort?
Yes. Then again, some sort of somehow the question you are asking, I end up with something addition to that. Anyway. So the thing is that yes, broadly stated, I can always say that suppose you are here, okay, and I want to cross-examine you. There can be two ways of doing it. That either I say that on such and such date you came to such and such address and you saw me using my iPad. That can be one. So this is a suggestion. So either you say yes to this or you say no to this. This is what is a suggestive. So all questions are suggestive. That is what is suggestive in nature. Or I can ask you that did you go to such and such address on this date? Okay. Or rather on this date, where did you go? Now I leave it to you. You can give out my address or you can say Taj Mahal. Okay. So this is what is I am asking you. It's sort of an interrogation which is all. Okay. So I would say that going a step away from what we are discussing, there is a marked distinction between cross-examination and interrogation. And the distinction is, in interrogation, the question which you asked is important. So while if I am a police officer, what I ask is important because even if you give out some other answer, I have still other ways of getting the truth from you. But in cross-examination, the position stands reversed. What I ask is not important. What you say is important.
Answer is important.
The answer is important. The answer plays a major, that is what is evidence. Not what I ask doesn't become evidence. And therefore, letting you lose is something of a nightmare, because when I say where were you on so and so, you are free to say anything. And thereafter there is no way I can stop you. So asking you open-ended questions is sometimes termed as a searching cross. This is not some legal word which is well defined. This is what is termed as a searching cross, that I am searching for an answer. And giving you a suggestion which you either may admit or deny is a suggestive cross. So my ideal, or rather my suggestion would be always go for a suggestive cross, because you can control answers. Even if you deny my suggestion, you have not brought any further material on record which I now need to contradict.
Correct.
Alright, so searching cross would be necessary when your client is trying to fight for his honor, one, or when there is no material at your disposal, you are making a person speak more and more in a hope, or I would say that you are shooting arrows in the dark basically, because you don't know, but by making him speak something more, you are trying to get some sort of contradiction in the case. But that is a dangerous path to tread. That remains to be the underlined part of it.
Okay.
Yes.
Now, Mr. Thatte, we have been talking about a lot of techniques, outlines, and methods of preparation. Finally, I would like to ask you that yes, this is all what we are doing. But is it so that only this will help us in cross-examination, or we need something more to be done?
So I have been right now suggesting you indirectly put me suggestions. This is exactly searching cross of mine. Anyway, what more needs to be done? So I will say what we have discussed about cross-examination is not even 2%. I would want to be that blunt about it. Reason. One, no matter how much you prepare for, witness is bound to say something which you have not thought of.
Hmm.
That remains to be the rule. No matter how many hours you spend, fact is, the moment, even if you ask a witness what is your name, he will come up with something, and that is what has happened. In a interesting MCOCA trial. Because I just had to buy time and I was looking for an adjournment, I just happened to ask what the name of the witness is, and he came up with an answer that my name is something else, and I have told police my name has to be something else. Now why he did that, God knows. But it just completely derailed me, because I had prepared everything based on what his name was in the charge sheet. So now why he did that is up to him. So the fact remains that cross is always going to go beyond what you prepared for. That is one thing. Secondly, ultimately cross is extraction of relevant facts. Now what is relevant, what is not relevant, what will kill the case of the prosecution, again depends on what the facts of that case are. And there are many facts which are rather hidden in the charge sheet. See, even police prosecution is not always fair. So there are many facts which are hidden, many opinions, many witnesses, their own notions, they play a vital role. So that is bound to be something different. All right. And therefore, knowing more and more about the current affairs, as we were just discussing, functionalities of social media, or rather any other thing, will play an important role. And don't forget that cross-examination is a technique which you develop over years. Okay, so if any young or rather aspiring cross-examiners, I would certainly say it one, that unless you go wrong in cross-examination, there is no way of going right. Okay, so cross will always go beyond what you have prepared. Witness will come up with some sort of a tricky answer which you are not ready for, and unless you go wrong, you can't go right. All right, that is it. Yes.
So Mr. Thatte, thank you very much for giving your time, and it was a nice discussion. Of course, the topic is very vast, but I think it was a nice narration which you have done and suggestions. So thank you for that. Thank you.
Thank you.